Chapter 21, Forms of Business Organization, presented by Kelly Herzik. In this lesson, we're going to cover two major topics. The first are the major forms of business organization, which are sole proprietorships, partnerships, corporations, limited liability companies, and the advantages of each form. Then we will cover some specialized forms of business organization. We will begin with the major forms of business organization. Exhibit 21-5 on page 480 gives a good summary comparison of the major alternative business forms we will study in this lesson. Deciding what the best business form is for a new business is one of the first and most important decisions a business makes. The risk of liability to the owner, the tax implications, as well as the amount of control an owner will have over the business, depends in large part on what form of business is chosen. Of course, the form of a business may change over time, particularly as it grows and its goals change. Many businesses start out small, such as a sole proprietorship or partnership, but grow into corporations. The advantages and disadvantages of a business form may vary from state to state, as well as what type of business can use a particular form in any given state. We will begin with the first business form, the sole proprietorship. A sole proprietorship is a business in which one person, the sole proprietor, is in control of the management and profits. It is a naturally occurring form of business organization in that if a person starts a new business like a lawn mowing business and does not think about the form, that business is a sole proprietorship. A sole proprietorship requires very few legal formalities and is the easiest to create. With a sole proprietorship, the sole proprietor has complete control over the business and can hire employees, determine business hours, and expand or change the nature of the business. A sole proprietorship is governed by one individual and is limited to the life of that person so that when the person dies, the sole proprietorship ends or terminates. Now, there are no requirements for forming a sole proprietorship in Kansas. A person wanting to start a business does not have to notify or file any paperwork with the Kansas Secretary of State. They can simply start doing business. Unlike many other states, Kansas does not even require or allow the registration of a sole proprietorship trade name, which is a doing business as name, a DBA. The sole proprietor keeps all the profits, but is liable for all the losses as well. The sole proprietor is responsible for the debts and obligations of the business. Income and expenses of the business are reported on the proprietor's individual income tax return, and any profits are taxed at the individual tax rate of the proprietor, which is usually higher than other business rates. A sole proprietorship is not a separate legal entity from the individual. If the business is sued, the sole proprietor is also individually responsible for any judgment, and the plaintiff can reach not only the assets of the business to satisfy the judgment, but also the assets of the sole proprietor as well, as long as they're not exempt under state law, and Kansas does have exemptions like homestead for a primary residence that creditors can't reach. Funding for the business may be limited to what the sole proprietor can provide or borrow, which can impede growth, particularly early on in the business. The next form of business organization is the partnership. Partnerships retain many of the advantages of a sole proprietorship, but do have some advantages sole proprietorships do not have. A partnership is a voluntary association between two or more individuals who are co-owners of a for-profit business. Each partner is an agent of the business. You recall under agency law that means that each agent can enter into contracts for the business and can be served legal process for the business, for example. Except in a few instances, partnerships are not considered a separate legal entity and end when one partner dies. The Uniform Partnership Act governs partnerships in most states and applies in the absence of a written partnership agreement. Partnerships do not normally have to file for organizations with any state. In Kansas, this type of business form is called a general partnership. A general partnership is a business that is co-owned by two or more people, even a husband and wife, who carry on the business as a partnership. The attributes of a partnership are statutory in Kansas under the Kansas Uniform Partnership Act, which is in Chapter 56A of the Kansas statutes. In Kansas, partnership filings are optional and are not mandatory. Partnerships are easy to create and generally do not require a filing at the state level or a written partnership agreement, though that is generally recommended. Generally, income from partnerships is taxed at the individual rate for each partner, though partners can also deduct any business losses. You can't do that as a sole proprietor. Absent an agreement to the contrary, all partners share equally in the right and responsibility to manage the business. Each partner is responsible for all the debts and obligations of the partnership. Each partner can be sued in their individual capacity and are liable for any judgments personally in addition to the partnership assets. Generally, one partner may have to cover losses of the business caused by the other partners, meaning that if one partner cannot pay for his share of the loss, the other partners may have to cover such losses under joint and several liability doctrines. A plaintiff can sue all partners jointly and severally, meaning they can sue all the partners or just one for the entire loss or the debt of the partnership. Next, we will discuss partnership duties. Partners generally have a duty of loyalty to each other and have a fiduciary duty to each other, meaning the partners must work in good faith for the benefit of the partnership. Partners cannot engage in business that competes with the partnership and must disclose any material fact affecting the business or benefiting one partner and not the others. Partners also owe each other the duty of obedience. Partners must obey the partnership agreement, and if a partner does not, that partner can be held liable to the other partner for any losses under indemnification principles. Partners owe a duty of care to the other partners. Each partner must perform their duties to the best of their abilities. Generally, honest mistakes made by partners in fulfilling their responsibilities to the partnership will not create liability for the mistake among the partners. Next, we will discuss the formation of the partnership. While not required, a partnership agreement is strongly recommended to ensure the terms of the partnership are upheld. As you may recall from our discussion on contracts, oral contracts are much more difficult to enforce than written ones are. A written contract, a written partnership agreement, protects every partner. They know what their duties, rights, and obligations are. A written partnership agreement is generally known as the Articles of Partnership. The Articles of Partnership generally include the name of the partnership, the names of all the partners, the duration of the partnership, the divisions of profits and losses, division of management duties, and the capital contributions of each partner. Now, there's something called partnership by estoppel. You may recall that courts use estoppel to enforce a legal obligation, even if one doesn't actually exist, when one party is acting unfairly towards another. So now partnership by estoppel can be created if a third party is aware of a misrepresentation of a partnership and does nothing to correct it, or if a non-partner represents himself as a partner and a third party reasonably relies on the statement to his detriment, the non-partner can be held liable to the third party for damages. A person who by conduct or words represents or allows himself to be represented as a partner in a firm is liable for the credit or loans obtained by the firm on the basis of such representation. This is also called presumption of partnership. For example, suppose in Morris, Bell and Associates there are two partners. One is Morris and the other is Bell. If King, an outsider, represents himself as a partner of Morris Bell and transacts with ABC Painting, then King will be held liable for any loss arising to ABC Painting who relied on the misrepresentation of partnership. Here, King is a partner by estoppel. Now, even if King did not make a representation of partnership himself, but knows that Morris is claiming King is a partner to get financing, and King does nothing to correct it, if Morris Bell defaults on the loan, King can be a partner by estoppel and liable for the loss just like the other two partners. This is also known as partner by holding out. Next, we will discuss termination of a partnership. Before a partnership can be terminated, it must go through both the dissolution stage and the wind-up stage. Dissolution is the change in the relationship of the partners due to any partner ceasing to fulfill their functions or obligations in the business. Dissolution is considered complete when any partner stops fulfilling the role of a partner, either by choice or by default. For example, the partner dies. Dissolution can be considered either rightful or wrongful. Generally, rightful dissolution occurs in accordance with the partnership agreement. If a partner dies or becomes mentally incompetent, if a partner is bankrupt, if the partners so fundamentally disagree that partnership cannot continue, or the partnership can only continue running at a loss of profits. Exhibit 21-3 has a complete list of the reasons for termination of a partnership rightfully. Wrongful dissolution occurs when the dissolution breaches the partnership agreement. After a partnership is dissolved, it goes through a wind-up period. If the partnership is rightfully dissolved, any partner can demand that wind-up begin. If a partner wrongfully terminates the partnership, that partner has no right to demand the partnership wind up. Winding up a partnership generally involves completing any unfinished partnership business, collecting and paying debts, collecting partnership assets, paying out any remaining profits, covering losses, and taking a final inventory. While a partnership is winding up, the partners still must fulfill their fiduciary duties to one another, disclose any pertinent information, and disclose the location of partnership assets. During winding up, the partners can engage in business activities that compete with the partnership. Next, we will discuss the types of partnerships. There are generally three types of partnerships. The first type of partnership is the general partnership. This is the type of partnership we've been discussing thus far. These are partnerships in which the partners divide profits and management responsibilities, and which have unlimited personal liability for each partner for the partnership's debts and losses. The second type of partnership is called a limited partnership, or an LP. These are partnerships in which each limited partner is liable for debts only up to the amount of his or her investment in the company. There must be at least one general partner who has unlimited personal liability for debts of the partnership. The way LPs are structured is that there is at least one general partner who is personally liable for all the debts, and then there can be several limited partners who are only liable for the debts up to the amount of their investment. But limited partners do not manage the company, but they do pay taxes on any profit received. If a limited partner manages the company, they risk personal liability for debts. They can be seen as another general partner. Usually states require that the word limited appear in the partnership name. An LP must register with the state, usually the Secretary of State, and if the registration is not filed, it defaults to a general partnership under the law. These types of partnerships are ideal for raising capital in a business. In Kansas, a limited partnership must be formed in writing between one or more general partners and one or more limited partners. LPs must have and maintain a registered office in Kansas, but it does not have to be the place of business. A Kansas registered agent must also be appointed to accept service of process. It must be registered with the Kansas Secretary of State. The third type of partnership is the limited liability partnership, or LLP. These are partnerships in which a partner's personal assets are generally shielded from claims of negligence, malpractice, or other wrongful acts committed by other partners or the employees those partners are directly supervising. Partners are only liable up to the extent of the partnership assets, meaning what they have invested in the partnership itself. They are most often used by doctors, lawyers, architects, accountants, and other licensed professionals where professional malpractice can be claimed against the business. In fact, some states limit this form of partnership to professional businesses. An LLP does not shield partners from their own negligent acts or omissions or other partnership obligations. An LLP is taxed like a general partnership, meaning each partner pays taxes on their share of the income at their personal rate. There are no LLP taxes directly. An LLP must have LLP or limited liability partnership in the name. Each LLP must register with the state, usually the Secretary of State. In Kansas, LLPs must have and maintain a registered office in Kansas, though it does not have to be a place of business. In addition, an LLP must have a registered agent in Kansas for service of process. And finally, the LLP must register with the Kansas Secretary of State. Now that we've completed discussing partnerships, we will now turn our attention to corporations. The most complex business structure is the corporation. The corporation business form separates business ownership from business control. A corporation is a legal entity formed by issuing stock to investors who are the owners of the corporation. It is a separate legal entity that is comprised of three groups of people: shareholders, directors, and officers. Shareholders are the investors who purchase a company's stock and are considered the owners of the company. The board of directors, headed usually by a chairman, are elected by the shareholders and are responsible for the overall management and control of the company. The board of directors, in turn, hire officers who run the day-to-day business. Officers are generally high-level management officials, such as a CEO, a COO, president, vice president, secretary, treasurer, or CFO. Because it is a legally recognized entity, a legal person, the corporation is generally responsible for the debts and obligations of the company. You may recall some of this from our discussion on constitutional law and how corporations came to be recognized as legal persons after the passage of the 14th Amendment. A corporation can be sued and be sued. It can be prosecuted criminally for some crimes. You may remember our discussion of corporate liability for crimes in the criminal law section. In most cases, the shareholders are not liable for and are insulated from claims against the corporation. Their exposure is limited to the amount invested. The corporation, as a separate legal entity, is also a separate tax entity, meaning the corporation pays taxes on profits and the shareholders pay taxes on any dividends or income they receive, which leads to double taxation. Corporations are created under state law and generally must file or register articles of incorporation with the state, usually the Secretary of State. Articles of incorporation are also known as a corporate charter or certificate of incorporation, depending on which state you're in. They generally contain the corporation's legal name, address of the principal place of business, the corporation's registered agent for service of process, and the types and amount of stock it will issue. In Kansas, a domestic corporation is one that is incorporated in Kansas and must file articles of incorporation with the Secretary of State. A foreign corporation is a company incorporated in a country, state, or jurisdiction other than Kansas. To do business in Kansas, a foreign corporation must file an application for authority to engage in business in Kansas. A professional corporation is comprised of a single professional or group of professionals who file both articles of incorporation and a certificate from their specific Kansas professional licensing or regulatory board with the Secretary of State. Shareholders of a professional corporation are limited to members of that specific profession. My law firm is a professional corporation. all the lawyers are either shareholders, employees, or both. They're not technically partners. Next, we will discuss a specific type of corporation called the S corporation. S corporations are corporations that elect to pass corporate income, losses, deduction, and credits through to their shareholders for federal tax purposes. S corporations make a valid election to be taxed under Subchapter S of Article 1 of the Internal Revenue Code. They're also known as small business, family, or closely held corporations. S corporations are legal corporations but are taxed like partnerships, meaning they generally do not pay taxes. They are a pass-through entity and the shareholders are the ones that pay tax on the income on their personal returns. S corporations cannot have more than 100 shareholders. Finally, S corporations are always formed under federal law by filing IRS Form 2553 with the IRS and cannot be formed under state law, meaning you cannot file the Form 2553 with the state and validly create an S corporation. However, they do first have to organize as a domestic corporation in a state and then file the Form 2553 within 75 days of formation. It's a two-step process that can only be completed at the federal level. First, a company must incorporate in a state, and then within the 75 days of formation, file the Form 2553 with the IRS. That is how you create a valid S corporation. S corporations are often family held, but they're not always small. Hobby Lobby is an S corporation. This was one of the justifications the majority of the Supreme Court used as a basis to permit them a religious exemption to the requirement under the Patient Protection and Affordable Care Act for employers to provide health insurance to its employees that covers birth control in the Burwell versus Hobby Lobby case in 2014. The last business form we're going to discuss in this lesson is the Limited Liability Company, or LLC. A limited liability company is an unincorporated business taxed like a partnership and has the flexible management options of a partnership, but has the limited liability of a corporation. An LLC is one of the newer forms of business organization and is generally recognized in every state, though the rules vary because the Uniform Limited Liability Company Act has not been uniformly adopted across the states. LLC members' liability is generally limited to their investment in the business, and they pay taxes in proportion to ownership share, which avoids double taxation similar to a partnership because the LLC is treated as a pass-through entity. LLC members may be involved in the management of the business without incurring personal liability, unlike limited partnerships in LPs. LLCs must register with the state, usually the Secretary of State, and have LLC or limited liability company in the name. Prior to forming an LLC, businesses need to check the rules in the state where the LLC is to be formed because the rules do really vary state to state. In Kansas, LLCs can be a professional group or even a single professional and have similar filing requirements as a professional LLP. A domestic LLC, one formed in Kansas, must file articles of organization with the Secretary of State and must maintain a resident agent. A foreign LLC, one formed in another country, state, or jurisdiction other than Kansas, must file a certificate for authority to engage in business in Kansas, Foreign Limited Liability Company application. LLCs have a lot of advantages. The LLC essentially provides the best parts of other forms of business organization and has become very popular. It is the most common choice of organization for new small businesses. It provides limited personal liability for every member for debts of the LLC. Unlike corporations, LLC profits and losses do not have to be allocated in proportion to ownership interest. Unlike corporations, LLCs are not required to hold annual meetings and draft minutes, so record keeping is simpler and more flexible. Unlike LPs, members do not have to give up management of the LLC to obtain limited liability. LLCs are unique in that they can be taxed as either a pass-through entity like partnerships, or at the election of the members, it can be taxed like a corporation. It can be useful to an LLC to be taxed as a corporation if most of the profit is put back into the business, which allows that profit to be taxed at the lower corporate rate. The choice of tax structure is an advantage that other forms simply do not have. LLC members do not have to all be U.S. citizens, unlike the S corporation, which requires every owner to be a U.S. citizen. As with corporations, ordinary business expenses such as salaries paid to members can be deducted from the profits of an LLC before the LLC's income is allocated to the members for tax purposes. Next, we will discuss some LLC formation issues. Generally, LLCs are formed by filing articles of organization with the state, usually with the Secretary of State. Information provided in the filing generally includes the name of the business with LLC in the title, the principal business address, the name and address of the LLC's registered agent for service, the names of the owners, and how the company's management is structured. To do business in other states as a foreign company, they will have to register in every state, which is a process generally known as qualification. Under most LLC statutes, an LLC will be governed by the LLC statute in the state in which it was organized, regardless of where it is transacting business. For the purposes of jurisdiction, an LLC is considered a citizen of every state in which its members reside. Remember that for diversity jurisdiction, corporations are considered a citizen of the state of incorporation and the state in which it has primary place of business. This rule does not apply to LLCs because an LLC's citizenship is determined by the residences of its members. If an LLC wants to avail itself of the federal court system, it should choose members from only one or two states or use a different form of business organization. To form an LLC, the members draft an operating agreement. Next, we will discuss LLC operating agreements. The LLC operating agreement is the foundational contract between its members as owners of the LLC. The operating agreement lays out LLC management, how profit and losses will be allocated, how ownership interests may be transferred, and how and when the LLC can be dissolved. Any matter not covered in the agreement will be determined by the relevant LLC state statute, or if not covered in the statute, by the common law and partnerships. A written LLC operating agreement is not required, but is advisable for the smooth functioning of an LLC. Just like with a partnership, if you don't have an LLC agreement, it makes it very difficult to enforce an oral LLC agreement. LLCs are either member-managed or manager-managed. In member-managed LLCs, all members participate in management and have an equal vote. In manager-managed LLCs, members select a group of managers to run the LLC who can be members or non-members, similar to corporate officers with the same fiduciary duty. In member-managed LLCs, decisions about the ordinary course of business are by a majority vote. However, voting must be unanimous to sell, lease, or exchange or otherwise dispose of all or substantially all company property, to approve a merger, to convert to a different business form, to undertake any act outside the normal course of business activities, or to amend the operating agreement. In member-managed LLCs, every member has the apparent and actual authority to enter into contracts on behalf of the LLC. Because of some of these issues, the larger a member-managed LLC gets, the more it makes sense to use a manager-managed LLC structure. In manager-managed LLCs, only the managers have actual and apparent authority to enter into contracts on behalf of the LLC. Non-management members do not have authority to enter into contracts. Next, we will discuss LLC dissolution. Under the Uniform Limited Liability Company Act, an LLC dissolves when any one of the following happens: the occurrence of any event specified in the operating agreement as a cause for dissolution, consent of all the members, the passage of 90 consecutive days during which the company has no members, or the issuance of a court order for dissolution of the LLC. Under the Uniform Limited Liability Company Act and most state LLC statutes, a member's voluntary withdrawal from the LLC, called dissociation, does not terminate the LLC. Next, we will discuss some specialized forms of business organization. In addition to the major forms of business organization, which we've already discussed, there are some specialized forms that have become increasingly important. The first of these is the cooperative. This is an organization formed by individuals to market products. Individuals in a cooperative pool their resources to gain an advantage in their chosen market. For example, farmers pool their resources to market crops, and dairy farmers pool their resources to market milk. They may be incorporated, which provides members the same general protections of a shareholder in a corporation. Today, every large cooperative is a corporation. They may be unincorporated, which are treated like partnerships, meaning members share joint liability for the cooperative's actions. Members are paid or receive dividends in proportion to how many times a year they engage in business with the cooperative. The next specialized form is the joint stock company. This is a partnership agreement in which company members hold transferable shares, whereas all the goods of the company are held in the name of the partners. These are a mixture of a corporation and a partnership and are usually not a separate legal entity. Members who hold shares of stock own the company, but the shareholders are personally liable for the debts of the company. A joint stock company issues shares similar to a public company that trades on a registered exchange. For example, suppose Bob holds shares of ABC Company, a joint stock company. These shares give Bob a percentage of the vote on ABC's management decisions, board elections, and the like. They also give Bob unlimited responsibility for ABC's outstanding unpaid liabilities until he sells his shares. The next specialized form of business organization is the joint venture. This is an association between two or more parties where the parties share profits and management responsibility with respect to a specific project. The parties to a joint venture can be individuals, small business, or even corporations. A joint venture can be an enterprise that may entail financing, producing, and selling goods, securities, and commodities. Participants in a joint venture usually share the profits and the losses of the joint venture. They do it equally, though that can be determined differently in the written joint venture agreement. Joint ventures are usually taxed like partnerships. They're usually treated like a partnership under the law, though there are some differences. For example, unlike the death of a partner, if a party to a joint venture dies, the joint venture is not automatically terminated. However, they are different from partnerships because they have a special joint purpose, such as making a new product, or a partnership is an ongoing business. Once the purpose of the joint venture is completed, the joint venture generally terminates. Next, we're going to discuss one of the more important business organizations, the franchise. Franchises are incredibly important to the market economy. A franchise is a business arrangement between an owner of a trade name or trademark and a person who sells goods or services under the trade name or trademark. A franchisor is the owner of the trade name or trademark in a franchise. A franchisee is the seller of goods or services under a trade name or trademark in a franchise. Franchises tend to fall into these three categories: chain-style business operations, a distributorship, or a manufacturing arrangement. In a chain-style business operation, the franchisor helps the franchisee set up a business run under the franchisor's business name according to the franchisor's usual methods, standards, and business models. For example, McDonald's, Pizza Hut, and Subway are all examples of chain-style business operation franchises. Then there is the distributorship. In this type of franchise, the franchisor licenses the franchisee to sell the franchisor's product in a specific area. For example, Ford Motor Company is a distributorship type of franchise where they allow car dealerships to sell their cars in certain areas. Then there is the manufacturing arrangement. The franchisor provides the franchisee with the technical knowledge needed to manufacture the franchisor's product. For example, Coca-Cola and Nestle are both franchisors that often use manufacturing arrangements with third parties to create a franchise to make Coca-Cola or chocolate. On this slide, I've summarized the advantages and the disadvantages to a franchise. Advantages to the franchisee are that they get help from the franchisor in starting the franchise. They get instant recognition due to the franchisor's strong trademark or trade name, and they benefit from the franchisor's worldwide marketing and advertising. But the franchisee gets disadvantages too. They have to meet the franchisor's standards or risk losing the franchise, and they have little to no creative control over the business. In a franchise, there are some advantages to the franchisor. The first is that they have a low risk in starting a new franchise, and they get increased income from franchises. But there are disadvantages, because sometimes they have little control over the franchise, and they can become liable for the franchise if it exerts too much control over its day-to-day businesses. Next, we'll discuss some general principles under franchise law. First, a franchise is not a legal entity. It is the franchisee who can choose the form of business organization that they want, such as a corporation or LLC, while operating under a franchise agreement. Now, usually the franchisor is larger and has more resources than a franchisee, and they generally are able to set the terms of the franchise agreement. They simply have more bargaining power. Often it can be a take it or leave it type of contract. McDonald's and Subway have standard franchise agreements, and it would be very difficult for an individual franchisee to make any material changes to those agreements. However, there are both federal and state laws that can protect a franchisee. For example, the franchise rule. This is published by the Federal Trade Commission, which requires franchisors to provide prospective franchisees with the material facts necessary for the franchisee to make an informed decision about entering into a franchise agreement. Then there is the Automobile Dealers Franchise Act of 1965, which prohibits car dealership franchisors from terminating franchise agreements in bad faith. And finally, there is the Petroleum Marketing Practices Act of 1979, which outlines the reasons for terminating a gas station franchise agreement. Next, we will discuss the creation of the franchise. To create a franchise, the parties enter into a franchise agreement. This will contain such terms as payments to the franchisor, the location of the new franchise, restrictions on the franchisee, and terminations of the franchise. Usually there is a large payment to the franchisor for use of the trade name or trademark, and it's often paid in a lump sum up front. And the franchisor will often receive a percentage of income from sales as well. Then there is the location of the franchise, and this is usually in the agreement and determines who will rent or build a building if it's needed. Hint, it's usually the franchisee. Franchise agreements usually contain a description of practices that are forbidden to the franchisee. These agreements set any sales quotas, standards for cleanliness, quality and safety, and record-keeping requirements that must be met by the franchisee. The franchisor can require a franchisee to purchase supplies from him at a set price. However, the franchisor cannot attempt to establish the price of goods for sales offered by the franchisee. This is due to antitrust laws, which prohibit anti-competitive behavior such as price fixing. The last topic we're going to cover in this chapter is termination of the franchise. The franchise agreement will determine how the franchise will terminate. The franchise agreement generally has a trial period for any new franchise. Usually 1 year is standard. If the franchisee does not meet the required minimum standards established in the franchise agreement, the franchisor can terminate the agreement. However, usually there are some notice requirements, meaning the franchisor must give notice of, and sometimes a right to cure, any substandard performance before termination. Usually terminations in these agreements must be for cause, such as poor performance or breach of the franchise agreement. While franchisors often give themselves broad powers to terminate a franchise, many states have passed laws to protect franchisees from wrongful termination, which is the most litigated issue in franchise law today. However, that's not the case in Kansas. Kansas is usually considered a non-registration state because there are no franchise registration requirements, nor are there any requirements enacted by law in Kansas that might protect franchisees. This is the end of Chapter 21.